Hi, everyone. This is Hunter Lott, your HR problem solver on demand. And this is take 5 from our series, Please Sue Me. This has come up the last couple of weeks on independent contractors. As we scramble to find and keep talent, as employees demand more flexibility, how do I manage this? And I've gotten the last couple of weeks I'm just going to make them an independent contractor. I said, well, it's not exactly that easy. And there's some risk versus reward to that independent contractor classification. So let's take just a couple minutes, look at this, and give you an update. This classification with the gig economy has been helpful, and employees want it. Many employees want to be an independent contractor, but it's not that easy. The EEOC has said, hey, people who are not employed by the employer, such as independent contractors, are not covered by the anti-discrimination law. So not only is there some flexibility, but also some legal protection. At the same time, we've got to be sure that they meet the classification. In the past, there had been about 19 questions, and totality of it's very vague. During the former administration, the Trump administration, they narrowed it down, implemented. Biden administration comes on and throws that out. A lot of play politics with this. So many of us employers are kind of caught in the middle. We had, though, just within the last couple of days, a court in Texas throw out the current administration's move and say, hey, you can't just unilaterally do this. It's not allowed. Again, legal. And so the default came back to the old Trump administration factors. So when you're looking at the independent contractor, control is still kind of a driving force. The attorneys will tell me, hey, it's about the control, it's about the ability or inability to profit and loss from the individual employee. And so right now, what we're left with are these kind of 6 factors. The control, if they're required to come to work at a specific time, they're wearing the company outfit, they're using company equipment, then your ability to show that they have control versus we do as employers is limited, and you're going to have a tough time. Individuals' opportunity for profit and loss, do they have another source of income? I look at those things and say, nah, if they're coming to work like everyone else and they're playing company softball and they're using company equipment, it's going to be real tough to justify the classification of independent contractor. Usually, how do they get caught? What typically happens is that the contract runs out, you say goodbye as the employer, they go down and apply for unemployment, not knowing that an independent contractor doesn't get unemployment. The state goes, we don't have a record of this person being an employee. So they may investigate. If they find out they indeed weren't, you got back taxes, potentially back overtime. So the stakes are pretty high here. And this has been a #1 enforcement area with the Department of Labor, both in the former administration and in the current one. With this new ruling, and again, we'll see kind of where this goes in flux, take a really hard look at your independent contractors and make sure they meet that definition. Have your accountant, your attorney, another set of eyes that look at that classification and make sure you're in line. I appreciate everybody. Thanks for watching. Go to the website, check out hunterlott.com for follow-up resources. I'm here to help. We'll see you next time on Take 5.